Hello. So in my company, we produce eggs, and we ship thousands of eggs all over the region every single week. And we have a delivery truck. And that delivery truck has been giving me a really hard time lately, and it's broken down a few times, and I finally brought it to a new mechanic who fixed my truck and told me that it was in perfect operating condition. I should have no problem. So I loaded thousands of eggs into the back of this truck, and as I was driving on my way to my first delivery, the truck broke down again. As I waited and waited for assistance, in below zero temperatures, the eggs froze and were ruined. I lost $10,000 worth of business. Can I sue the mechanic who fixed my truck for that? Who knows? Of course, anyone can sue anyone for anything. Whether you're actually going to prevail or not is a whole different question. Welcome to Business Law, Business 155 at Greenfield Community College. This is the first video in a series of videos we'll be producing throughout this course to address very specific topics that I've outlined in the syllabus. The law is not an easy answer. It never is. And I see people on social media all the time asking questions like that and saying, can I sue? What's the law? And an awful lot of people quite frankly, whose opinion is worth no more than the keyboard they're writing on, all have wonderful information and, oh, yes, you can, no, you can't, you'll win, you won't win. As I said, the law is extremely complicated. And it's not a question of, well, what does the law say? Because usually, legal decisions are not based on what the law says. We are a common law nation, and we'll be going a lot more deeply into that concept as we go through the course. But what it means is that judges look at fact patterns that have previously occurred over the years, and they try to see if the current fact pattern before them is similar to or dissimilar to the decisions that have gone before. And they ask themselves, what have judges in the past said about this? So a lot of what we look at this semester will deal with looking at legal cases. Now, as we go through this semester, we're going to be looking at the top content areas that are most likely to affect you in business. The first, of course, is contract law and contracts and what makes a valid contract. And if a contract is breached, what are the remedies that are available to you? We're going to look at torts or negligence, which is similar to someone is walking in front of your business and they slip on the ice and fall and break their leg. Are you responsible? Did you sell them a product that malfunctioned in such a way that it caused harm to them? That's torts and negligence. We'll also be looking at shareholder rights because obviously many businesses in the country today are corporations or are incorporated. That doesn't mean they're big. It just means they've been incorporated. But because of that, there are special laws at play and special rights that shareholders in that corporation have. And finally, we'll be looking at the landlord-tenant rights and responsibilities. Because when you go to a shopping center and you see all those stores in that shopping center, chances are very high that none of those stores actually own the storefronts that they're in. They're renting from a real estate development company. And so as you maneuver within the business environment, these are the topics. Do I have a responsibility to my shareholders? What do the contracts say? Can I get out of it? Can I amend it? Am I liable for damages that people incur, which is the torts and negligence issue? And what are the rights I have as a tenant in someone else's building? In order to understand those topics, in order to get there, we need first to look at the structure of the American judicial and legal system. And this is going to take a few weeks. You probably have recently heard that in 2022, the Supreme Court struck down a provision that the Biden administration had tried to enforce, requiring all employers with 100 or more employees to require them to be vaccinated or be tested against COVID. And this was struck down. And of course, much of what is reported in the media is that the court struck down the idea of mandatory vaccines. They did not. They did not make a ruling as to the efficacy or the usefulness of vaccines. They did not decide a policy as to whether they were good idea, whether this was a good idea or a bad idea. In fact, they really didn't decide the issue at all, because the specific issue before them was whether they should allow it to go forward or stop it while it was being litigated in a lower court. The court decided to stop the program while it was still being litigated in a lower court. In a concurring opinion, which means I agree with the decision, but I want to write a little more, Justice Gorsuch wrote, "The question before us is not how to respond to the pandemic, but who holds the power to do so. Did the executive branch, through the Department of Labor, have the authority to do that, to require that? Or is that something that Congress had to do, or that states have to do, or that individual businesses are permitted to do or not?" So very often the media reduces these very complicated issues into headlines and clickbait and sound bites. But what's actually going on behind the scenes, beneath the surface, when you dig into it, is much, much more complicated than that. For instance, we often think, well, the law, what is the law? And we ask that question. We just want to know what the rule is. Well, most of you probably know what a no trespassing rule is. Well, what if there's a no trespassing sign on someone else's property, and you go onto that property because you're looking for a lost child? Are you still trespassing or not? Or you know what a speed limit is. Speed limit says 45 miles an hour. You can't go over that. Well, what if you're rushing someone with a medical emergency to a hospital? Can you? See, all of these questions, again, are much complicated than simply looking at someone's idea of, well, this is what the law says, so that's it. In order to understand these issues, we are going to look at legal cases, and we're going to spend the first several weeks looking at how to understand, how to read, how to analyze, and how to understand a legal case and what the ruling really means. To give you an example of some of the issues that come into play here, I'm going to introduce you to two cases right now in this video. Quill versus North Dakota and South Dakota versus Wayfair. They're a pair of cases that have happened within the last 40 years or so, and they had very different outcomes. So both of them are based in part on a section of the Constitution called the Interstate Commerce Clause, which is something that we're going to be looking at over and over in this course. The Interstate Commerce Clause, in Article 1, Section 8 of the Constitution, is where the Constitution gives Congress and the federal government the right to regulate commerce among the states. And the background and the reason for this is that before we had a constitution, some states were playing favorites. They were saying, well, if you make a boat in our state, there's no tax on it. But if someone in the state next door makes a boat and wants to sell it here, we're going to tax it. Or we're going to prohibit them from selling it here. Or we're going to count the coinage or the money coming from another state at a discount compared to what our state does. So there was all of this confusion and obstructions in between the states prior to the Constitution. So when the Constitution was written and adopted, Congress gave the federal government the right to regulate commerce between the states. Now, just because that's what the Constitution says, that leaves open the question of, well, what qualifies as commerce and what doesn't? And if Congress is given the right to regulate interstate commerce, does that mean that the states don't have any rights to regulate interstate commerce? And so this is a very simple clause that has a long history and many legal decisions and a lot of impact on a day-to-day business operations. So now let's go to these two cases. The first one is Quill versus North Dakota, or Quill v. North Dakota. And cases are most often referenced by who the parties in the legal case are. And a little v is used, Quill v. North Dakota, to represent the Latin word versus, meaning against. Who's against who here? This case goes back to 1992. You may be familiar with the Quill Manufacturing Company. They are like Office Depot or Staples. They produce office supplies, pens and pads and paper and all the kind of things that you would pick up, let's say, at a Staples. But they did almost all of their business through mail order business. And in fact, they had no office in North Dakota. They had no salespeople in North Dakota. They had no physical presence in North Dakota whatsoever. The only things they sold there were things that were sold and delivered via mail order. North Dakota passed a law that said, that required retailers from out of state to collect sales tax on sales made in North Dakota. And Quill said, whoa, 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 wait a second. You have no right to tax us. We are not in your state. We have no physical presence in your state. We don't have land there. We don't have a warehouse there. We have absolutely nothing there whatsoever. Well, North Dakota argued back and said, yeah, but you send 24 tons of catalogs into North Dakota every year, and we have to dispose of them, so we have an expense as a result of your doing business here. So this went to trial, and in the lower level courts, Quill won. It was appealed to the North Dakota Supreme Court, and Quill lost. And so this case ended up at the U.S. Supreme Court. And Quill said, look, we have no physical presence in the state, and you can't just allow states to be taxing anyone they want to anywhere in the country. This is an infringement on interstate commerce, which is the exclusive province of the federal government, of Congress. Quill can't force a corporation in Delaware to start collecting sales tax and sending it back to North Dakota. The Supreme Court agreed with Quill, and Quill won the case. And the court at that time said, look, we've always used the physical presence rule as the criteria by whether or not a state is allowed to tax an out-of-state corporation or collect sales taxes from an out-of-state corporation. And anything less than a physical presence, the state really doesn't have the authority to go after them. This is interstate commerce. We don't want to disrupt interstate commerce, so Quill won. Now we fast forward. We go to 2018. Back to the Dakotas. This time, it's South Dakota. South Dakota passed a law doing essentially the exact same thing that North Dakota had done years earlier. South Dakota said, if you are doing business in this state, if you have $100,000 or more in sales, and you have 200 or more sales, that's significant enough that we are going to require you to collect sales tax from people who buy your goods and services and send it to the state of South Dakota. Well, this time things turned out a little different. Of course, the difference between 1992 and 2018 is the difference between the internet exploding as a mechanism for purchasing and selling goods and services. This time, in a 5-4 decision, with Justices Ginsburg, Gorsuch, Kennedy, Alito, and Thomas on the same side, which is quite an unusual array of justices if you know anything about them individually. They wrote a 40-page decision in which they said that South Dakota could indeed tax an out-of-state corporation. And in the decision, they lay out their reasoning. They say, quoting from the decision, "A business with one salesperson in each state must collect sales taxes in every jurisdiction in which goods are delivered. But a business of 500 salespersons in a central location and a website that's accessible to every state does not need to collect sales taxes with otherwise identical nationwide sales." Doesn't make sense. Continuing, if the Commerce Clause was intended to put businesses on an even playing field, the physical presence is hardly a way to achieve that goal. And so in 2018, the court decided, with the advent of the internet and a change in society, we no longer need to stick to the physical presence rule. It was a change in the law. The Constitution hadn't changed. Congress hadn't made any laws in the meantime saying what states could or couldn't do in this regard. The North Dakota law and the South Dakota law was almost exactly the same. The arguments Quill and Wayfair made were almost exactly the same. So what changed? What changed was that society changed. And because society changed and there was so much more of a presence of internet buying and selling, and the ability to simply access the web in your house or at your business to buy or sell. Because of that, the facts today are different than what they were 20 years prior or 40 years prior, and therefore the law applies differently. This is a great set of cases to show how the written law may not change at all, but the law lives. It changes to consider new fact patterns. So, in this first lesson, we're going to be looking at how to read, analyze, and understand a case. And this is pretty foundational to everything else we're going to look at moving forward. I look forward to spending this semester with you and pulling apart some of these cases and some of these decisions so that we can come to a better understanding of how the law applies to your day-to-day business operations. This is Tom Simmons, and I'll see you in the next video.